on the current nurses' strike, a story we are keeping an eye on for you now. Also, the Court of Appeal this morning concluded the hearing in a case in which the Independent Electoral and Boundaries Commission is seeking to reverse a High Court ruling on the tallying of presidential polls in the August 8th general election. The five-judge bench is expected to give its ruling on the matter on the 24th of this month. Court of Appeal President Justice Paul Kihara had stated that the bench will not entertain sideshows since the legal issues under consideration are complex and have attracted considerable public interest. The electoral body is aggrieved by the April 7th decision by the High Court judges Agri Muchelule, Weldon Korir and Enoch Chachamuita that results of the presidential race should be declared exclusively by the 290 constituency returning officers and not subject to confirmation by anyone else. The electoral body argues that the IEBC chair should be the returning officer of the presidential poll. Moremi Mwangi has been covering this for us since yesterday. This is day 2. He now joins us live from our city center studios. Moremi, what can you tell us from the Court of Appeal today?
Good afternoon, Kitili. For starters, the ruling is on the 23rd of June. That's when the judges will deliver a verdict which could potentially see yet another appeal filed before the country's top court, the Supreme Court. Today was the turn for an interested party in that dispute, the National Super Alliance, to make their presentation before the judges, as well as an amicus curiae to the case, the Katiba Institute, and a rebuttal from the IEBC. But most importantly, on the arguments that were witnessed in court today was the insistence by NASA that the returning officers, the 290 returning officers, are employees and are part of the IEBC, and therefore the verification process that the IEBC is seeking to do at the national level can be done at the 290 constituencies, and part of that being a statement made by the Katiba Institute that the presiding officer in the polling station, even before the results get to the constituency returning officer, has an opportunity to count the votes, to recount, and to do that up to 3 times pursuant to the regulations on the general election. And therefore, that would, in a way, forestall the possibility of errors from, say, polling station A or B finding their way to the constituency tally, because the High Court ruling, as it stands now, has placed the finality at the constituency level. But the IEBC has insisted that the presidential elections in Kenya are different from the elections for the other elective seats that are contested on the date of the elections. And of course, they argue that the Article 136 of the Constitution is specific to the presidential election and gives a clear outline of what happens from the time the voter goes to cast their ballot to the ultimate declaration of the winner by the IEBC. And the IEBC argues that part of that process is a verification of the tally from the constituencies at the National Tallying Center. But of course, the opposition has insisted that with the IEBC having the capacity to recruit and to vet the returning officers that they deploy to the 290 constituencies, then from that stage they can weed out the presumed rogue ROs that might be used to inflate the results or to manipulate the outcome as they receive them from the polling stations, and therefore can't seem to ask for those powers to verify the results again at the national level. But interestingly, there has been an argument that has consistently been fronted by the Attorney General that the argument in the petition that was before the High Court, which was the genesis of the appeal before the Court of Appeal, is a political question, and that political philosophies of that nature ought not to find their way into the court. The judicialization of politics, so to speak, is the phrase that we are using in the courts today. But of course, the opposition outfit has insisted that part of the reason why the petitioners moved to court was because the elections process is a constitutional one, and they were seeking an interpretation of the Constitution at the High Court, of course, the aftermath of which is the appeal that is before the Court of Appeal today. Ben.
Muribi, from the submissions from both sides, what are the vibes coming from both sides? Are we, with obviously NASA standing their ground and IEBC seeking clarifications, are we likely to see this issue finding its way before the Supreme Court?
Well, before the adjournment of the court today, I had an opportunity to speak to a few of the legal team in that particular courtroom, and it was clear that whichever way the judgment goes on the 23rd of June, a subsequent appeal at the Supreme Court could be inevitable. Remember, in the past, the Chief Justice has been categorical that any court cases relating to the 2017 elections will be disposed of early enough to, of course, prepare Kenyans also psychologically about the preparations for the 2017 elections. Remember, there is a pending case before the High Court regarding IEBC's recent reshuffle of constituency returning officers because the opposition which filed that case at the High Court argues that key stakeholders in the 2017 elections were not adequately consulted on the criteria for that particular reshuffle. And in a way, today, during the hearing of that appeal, when NASA was making their presentation, they made reference to that case in which the IEBC is a respondent, and IEBC in that particular case is defending the redeployment of returning officers that happened earlier in the year in readiness for the August elections. And one of the statements that came from NASA's lawyer, Paul Mwangi, was that if IEBC has confidence in these 290 persons that they have deployed across the country, then they ought not to be worried about the sanctity of results that will be coming from the constituencies, because these are persons that they have vetted before giving them that position. But on the constitutional side, Kitili, there has been an argument that the plain writing of the Constitution could, that interpretation by the High Court, the argument has been that it in a way does not reflect the spirit and letter of the Constitution in the mind of the drafters of that document, according to the Attorney General, because the context under which the 2010 Constitution was written was that following the 2007 altercation that was occasioned by the disputed presidential results, and they even cited the Kregler report as a justification for the IEBC to relook results from the 290 constituencies at the national level to ensure that discrepancies similar to those that occasioned the disputed 2007 elections do not recur in 2017. But the opposition and the other respondents in the appeal have insisted, besides the AG, of course, have insisted that the Constitution is clear and the finality of results at the constituency level cannot be changed. Kitili.
Thank you, Muremi Mwangi, live for us, covering this issue for us. As he is reporting there, the Court of Appeal expected to issue the final